Good morning.
Go on the record this morning. I just wanted to. No, it's not on. Thank you, Dave. Just wanted to go over the schedule, and then we'll get on the record. Mr. O'Loughlin, do you have witnesses O'Donnell and Neal available this morning?
Yes, we do.
Thank you. Counsel for Meeg is not present. I'm sorry, can you, what is your name?
Jeff Bain.
Jeff, and you represent the union?
Yes.
Okay, thank you. With respect to staff, Mr. Albert, how are we in terms of having staff witnesses appear today?
They are available, Your
Okay,
Honor.
all of them?
That I'll have to check.
Okay, at least Mr. Cross is here, and all of them are available. All right, good. Any other matters before we go on the record?
No, Your Honor.
Okay. Good morning. We are on the record in case number 9484, the third day of the trial-type evidentiary hearing in the matter of the application of Baltimore Gas and Electric Company for adjustments to its gas base rates. We concluded yesterday with all of the company's witnesses. We'll begin today with witnesses from the Office of People's Counsel. Mr. O'Loughlin, would you like to call your first witness?
Yes, at this time, OPC would like to call Kevin O'Donnell.
Mr. O'Donnell, if you will remain standing.
Good morning. Could you please state your name and business address for the record?
Yes, I'm Kevin O'Donnell, Nova Energy Consultants. Address is 1350 Southeast Maynard Road, Suite 101, Cary, North Carolina.
And you're a witness for our Office of People's Counsel?
Yes, I am.
Do you have in front of you your direct testimony dated September 14th consisting of 31 pages?
Yes.
And do you also have in front of you your exhibits dated September 19th consisting of 2 pages?
Yes.
And were those prepared by you or under your direction?
Yes, they were.
Do you have, at this time I'd like to have the direct testimony marked as OPC Exhibit 5 and the exhibits marked as OPC Exhibit 6, if those numbers are correct.
So marked as 5 and 6.
Do you have any corrections to this testimony?
No.
And if I asked you the questions as they're written, would the answer still be the same?
Yes.
And does this constitute your full and complete testimony in this case?
Yes.
At this time, I'd like to move Exhibits 5 and 6 into evidence.
Seeing no objection, OPC exhibits number 5 and 6 are moved into evidence.
Your Honor, I don't have an objection. I just want to clarify, the exhibits are just the corrections, the 2, or is it all of the exhibits?
It's the 2 pages
Okay,
dated September 19th.
Okay, that were corrected?
That's correct.
Okay, thank you.
Thank you. At this time, Mr. O'Donnell is available for cross.
Thank you. Who would like to begin? Mr. Albert?
Staff has no cross.
No.
The laborers have no cross, Your Honor.
Well, that was sooner than I was expecting. Good morning, Mr. O'Donnell. I'm Beverly Sucre on behalf of BGE.
Good morning.
Just a couple questions for you. In your direct testimony, you proposed an overall rate of return of 6.53%, correct?
Yes.
And that's, the calculation is set forth on page 46, I believe, of your direct testimony?
Yes, it is.
Okay. And looking at your calculation, you disagreed with the company's equity ratio of 53.4% that was in the direct testimony?
Yes.
And instead, you're proposing a capital structure that uses the equity ratio adopted by the commission in our last case?
That's correct.
Which was 51.9%, correct?
Yes.
Mr. O'Donnell, are you aware that the capital structure that was in Mr. Holmes's direct testimony was based on our projections for July 31st?
Yes, I remember that.
Okay. Did you get a chance to review the supplemental direct testimony filed by company witness Holmes?
Yes.
Okay. And do you recall what the actual equity ratio was at July 31st?
I want to say it was 52.85, if I remember correctly.
Okay. Not quite. Do you have a copy?
Not with me, no.
Okay. May I approach, Your Honor?
You may.
Thank you. Okay. The calculation is on page 3, and this was Company Exhibit 14
Okay.
is what we're referencing.
54.3.
Okay. And, Mr. O'Donnell, are you aware that the company issued $300 million of long-term debt in September 2018?
Yes.
Okay. Did you get a chance to review the rebuttal testimony that was filed by company witness Holmes?
Yes.
Okay. And do you recall what the equity ratio was in that filing that Mr. Holmes proposed?
Not as I sit here, no.
Okay. Do you have a copy of that
No, I
testimony?
don't.
Okay.
Thank you.
Okay, and that is actually on page 3 as well, if you turn.
There's the 52.85 I referenced earlier.
Okay. And so the actual capital structure used as of September 30th reduced both the company's equity ratio and the overall rate of return, correct?
Yes.
Okay. Mr. O'Donnell, one last question. Are you aware that staff witness Juan Carlos Alvarado, in his rebuttal testimony, is recommending that the commission use BGE's actual capital structure as of September 30th?
I'm aware of that. I'd have a different stance on that, but yes, I'm aware.
Okay. That's all, Your Honor.
Thank you. Any redirect?
None.
Do commissioners have questions?
Hey, just two quick questions.
Yes, sir.
I'm interested to know the company current ROE is 9.65%. Is that's correct? Is that?
Yes, sir.
But you are recommending it be reduced to 9%.
Yes, sir.
And so, why a reduction? What in these circumstances has changed since the 2016 when this was set that you would actually suggest we reduce ROE? Is it just do we think we got it wrong last time, or what's the rationale?
Primarily, if you look at chart 2, page 5 of my testimony, you see it's a Dow Jones utility average. And what's happened is that the stock market continues to go up. And anytime you buy any asset, stock or house, any asset, and you continue to pay more and more for it, your expected return is going to go down. And that's what's happened here, is that the stock market continues to go up. Earnings are driving it, but the stock market continues to go up. I can remember back when I first started doing this work, market value of utilities was well less than book value. Now it's the complete opposite. And part of that is because the market's just gone so high, so fast. And so the answer is, what's happened over the past 2 years? The stock market has happened. And I capture that in my discounted cash flow, my DCF model. And that's reflected in the price of the DCF, and it's reflected in the return on equity that comes out of the DCF. But the quick answer is the market.
Okay. Well, I think we're all getting kind of whiplash by the market these days. It's all over the place. Just one other quick question. On page 15 of your I believe it's your direct, yeah, because you only had direct testimony, you make the comment, I think this is with the comparable earnings test, that the number of available gas utilities needed to develop a reasonable, reliable, comparable group is dwindling. Is this going to the point that maybe this is not even a useful measure anymore, or what should we glean from that statement there?
Well, it's definitely dwindling. Piedmont was bought by Duke, and of course Atlanta Gas Light, AGL Resources, was taken out by Southern Company. They are getting, the group is getting thinner. At some point in time, you're right, we're going to have to take a step back and say we need more companies in this group. We're not there at that point, but if we lose a couple more, yeah, we're going to have to figure out something else to do. Maybe we'll be able to look at electric gas combos, and typically gas utilities receive a lower rate of return than electric utilities. So if we looked at electric gas combos, we could do some adjustments thereof and recognizing the smaller returns on the gas utility versus the combo.
Okay, great. Thank you.
Quick questions, Mr. O'Donnell. If I look at your bio, you've been doing this for a long time, 30 some years, 34 years. Mr. McKenzie recommends a 20 basis point adjustment for attrition. Can you tell us, have you seen this adjustment before, and what is your opinion of this type of adjustment for attrition?
I've never seen it. In my 33 years of doing this kind of work, and I did ask Mr. McKenzie that question in this case, and I did get an answer from him where he hasn't found it, or he hasn't done the analysis. Let me be very clear on that. I don't want to speak for him, but it's something I've not seen before. I don't like it. I don't see how what we're talking about here is any different than what you see throughout the utility industry. I've got municipal clients, I've got university clients, and we all deal with the same issue. And so I don't agree with it.
And let me ask you about the 10 basis point flotation adjustment. There are multiple subsidiaries of Exelon. Exelon issues the stock. How do you appropriately allocate the costs of that to the various subsidiaries? How's that done? Have you seen that done?
What I have seen in some jurisdictions is that you would allocate the actual flotation costs, the legal cost, banking cost, printing cost years back. You would take all these costs and you would allocate it based upon equity before the issuance. Obviously, the equity rate, total dollar amount of equity of all the subsidiaries, and you get a ratio of the total, and then you allocate those costs based upon the equity that's currently in the balance sheets of the subsidiaries. So you just allocate it that way. And then once it gets to the subsidiary for utilities, you obviously have the choice of amortizing that cost, and you're allowing full recovery at that point.
But those costs aren't recorded in the books of the utility, right?
I can't really speak for what the utility is recording them. What I'm saying is, for regulatory purposes, you can calculate that and you can amortize that cost out.
I see. Okay, thank you. Thank you, Mr. O'Donnell.
Thank you, Mr. O'Donnell. Do the parties have any questions based on Commissioner Richard or O'Donnell's questions?
No, Your Honor.
Thank you.
One quick clarification. I misspoke earlier when I identified the number of pages. It's 55 pages. I just wanted to make sure all of the testimony made it into the record and not just some portion thereof.
And that's for OPC Exhibit number 5.
That's correct.
Okay. Thank you, Mr. O'Donnell. You are excused. Your next witness.
Your Honor, the Office of People's Counsel calls Alan Neal. Good morning, Mr. Neal. For the record, could you please give us your name and business address?
I can. It's Alan R. Neal, and I work through Daymark Energy Advisors in Worcester, Massachusetts.
And are you here today on behalf of the Office of People's Counsel?
I am.
Now, Mr. Neal, do you have with you 3 sets of testimony that I'll go through in order? First, your direct testimony filed on September 14th, 2018, consisting of 43 pages of text, your CV, and attached exhibits.
I do.
And you also have with you your rebuttal testimony filed on October 12th, 2018, consisting of 13 pages and 1 attached exhibit.
I do.
And finally, do you have with you a red-lined errata to that rebuttal testimony, which was filed this past, I guess that was yesterday, Wednesday, November 7th, 2018?
Yes.
Your Honor, I'd like to have Mr. Neal's direct testimony marked as OPC Exhibit 7, his rebuttal testimony marked for identification as OPC Exhibit 8, and the errata to his rebuttal testimony marked as OPC Exhibit 9 for
So-
identification.
So marked.
Now, Mr. Neal, were these testimonies and exhibits prepared by you or under your direction and control?
They were.
At this time, do you have any corrections to any of these testimonies or exhibits?
Not at this time.
And if I were to ask you the questions contained in the testimony, would your answers be the same?
Yes, they would.
And do you adopt this as your testimony for this proceeding?
I do.
Your Honor, at this time, I'd like to have what has been marked as OPC Exhibits 7, 8, and 9 admitted to the record in this proceeding.
Seeing no objection, OPC Exhibits 7, 8, and 9 are moved into evidence.
And the witness is available for cross-examination. And Your Honors, in case the redlined versions did not make it to you, I do have some extra copies, but we ask that they be in color. I hope they turned out in color for you all. I'm sorry if they did
Well,
not.
we have black and white copies. I think they will.
I do have a couple color copies if that makes it easier for you on the errata
Okay.
version. So.
If you have them, if you could pass them to Mr. Collins.
Can't do anything these days without living color. Just can't.
A little easier at identifying.
They can fight over it.
Mr. Bain, do you have questions for the witness?
No questions, Your Honor.
Sorry, Your Honor, no questions.
People don't usually get this choked up.
Ms. Sikora, Mr. Gagan.
No questions, Your Honor.
The witness has come all this way. Let us take a look at these. Okay, very well. Do commissioners have questions of Mr. Neal? Commissioner Herman.
Good morning, Mr. Neal.
Morning.
Sorry. Good morning, Mr. Neal. So, in your testimony, you suggest that the safety and reliability projects are dominated by the Granite Line project. Do I have that correct?
That's the transmission.
Yes.
Yes.
So, and you say that's less risky. Can you explain to me why that has less risk?
Typically, transmission lines bring gas to a distribution area. They're not necessarily downtown, near homes, etc. So, the operating characteristics are different. The conditions that they're in are different. So, they are less risky.
Okay, so it's the operating characteristics, not the
Right.
construction or anything.
Correct.
Okay. On page 26 of your direct testimony, I believe you said that the commission, as part of STRIDE, let's see, where am I? Sorry.
Of my original testimony, I'm sorry?
Yes, your direct testimony. Is it your understanding that the commission pre-approves costs in stride when it accepts a list of projects?
The answer is yes. In other words, the company is charged with coming up with a list of potential projects. And I'm sure there's some give and take over the year, but essentially you approve a basket of money based on those projects.
Okay, thanks. So, in discussing the CPI index adder, and you do agree that there is likely some inflation over time, is that correct?
Oh, of course, yes.
Right.
Yeah.
So, if the adder were, say, a smaller percent, something that you could feel fairly comfortable that there is at least that level of inflation, would you still be opposed to the adder?
I would be more amenable. However, I would just say that in today's time, companies have been shielded from most risk. For instance, if you take a look at the weather normalization, that used to be an industry's biggest risk, and now they're insulated from that. As you take a look at labor is already being increased because they have signed unit contracts. So now you have all the stride money going in, and they're actually earning on it as they put it in. When I was doing rates for our company, the single largest driver to why we would come in for a rate increase would be the installation costs of mains and services. And here you are, you've insulated them from that largest reason. So we're down to really smaller and smaller things. And additionally, one of the reasons in this case why I'm a little ambivalent to give them interest cost on those things is that they have been doing stride for, I forget, 4 or 5 years now. If they're doing a really good job at taking out the worst gas lines, that they have in their system up front, there should be a downward pressure on how many leaks the company needs to fix annually. And in fact, they should be trending down. That, coupled with the fact that they already recover, let's say, as I took a look at their cost to fix leaks, it's a bar graph, and it shows that there is a down year. So the cost to fix leaks is totally controllable by the company. And so those things coupled together should suggest that there's a real downward pressure on the need for them to have an inflation adjustment. Because the costs for leak repairs, maintenance of mains and services should trend down if they're doing a good job in stride. And that, in my opinion, is a great offset to interest.
So, have you reviewed and provided testimony on the leak rates that have been discussed in this case by Mr. Acosta and the other witnesses?
Have
you reviewed that and
quite some
provided
time
testimony
ago.
on that?
Quite some time ago, yeah.
Okay.
Yeah.
So,
I guess I've been involved in stride since the inception here in Maryland.
So your proposal is to reduce BGE's ROR because of the gravity, in your view, of the situation. Is that correct?
Yes.
Have you done an engineering review of the situation that was the result of the explosion?
No. No. You're talking about the meters.
Yes.
I can explain my position on it if you'd like.
Oh, that's fine. I just wanted to know whether you had, reviewed all of the material
I
associated
read
with
the NOPV and things like that, but
Uh-huh.
That regulation goes back to, I forget, 60s or 70s. The gas company always must locate its facilities in a safe manner. So forgetting for a moment that there is some specific language from PHMSA about, what's required, like ventilation, etc. The company still must make sure that its mains and services are protected. So above and beyond all that, as I looked at the fact that they've discovered somewhere between 3,300 and, let's call it 8,000 sites, that didn't happen all at once. And all this time, they were supposed to be making sure that those structures were protected from potential damage. And right now, we have somewhere between 3,300 and 8,000 sites out there that have problems relative to safety. That's the customers are exposed. And so for me, I want to make sure that the company works as quickly as possible to eliminate those issues. It's at the best interest of the company as well as the customers. And I think the way I structured it was to incent them, because I understand the importance of return, and I don't think there's a better incentive for a company than, if they want to earn their return, then they need to operate safely. And so I think it was just a good, rough justice like Mr. Acosta was aiming at, but slightly different. I think it pushes more pressure on them to ameliorate the situation.
Did you say rough justice?
Yeah, I would call it rough justice, because it's very difficult to come up with an exact number for this consequence.
Do you consider this a penalty on the company?
Well, I would tell you that it is somewhat a penalty, but it is a penalty that recognizes that the company has allowed 8,000, more or less, locations to be in violation of regulations. And if you're operating like that, I don't know, what do you think you should be under? I think a penalty is appropriate.
Okay, thank you very much.
You're welcome.
Mr. Neal, just to clarify your last point, do you believe that BG&E was in violation of federal regulations with respect to this incident?
I will answer it telling you my history. We ran afoul of that issue at Essex County Gas. And we put together a program going back in the 70s and 80s to install bollards and things like that. To install bollards and to move meters from the inside to the outside, but we may have installed a bollard there. I mean, you must prevent any damage to the piping. So they've identified these spots. So they've admitted that there's all these spots that need protection.
Thank you. Commissioner Richard?
If I could just follow up a little bit on Commissioner Herman's question. So we're talking about the rough justice that you're advocating. So your proposal would go beyond than what the staff is requesting.
I'd say
and that is that they would suggest to just split 50%. Only 50% would be allowed for recovery of the primarily the labor costs for the mitigation program, meter mitigation program. Is that correct?
Yeah, but at the end of the day, if they complete the work, they're going to get their 2% back. And so their earnings should go up.
So the
the
20 basis
department-
points would come off at that point then.
Right. In the department situation, they're going to reduce their rate base right up front.
Okay. Just a question about the rate base. So in this meter mitigation program, do the company shareholders, do they benefit from this program at all? I mean, are we adding to rate base, and thus that goes into a higher revenue requirement and return?
But typically, anytime you install pipe, you increase rate base.
But will
in this
specifically
case,
to this program,
yeah.
is there an amount that you would be able to calculate that said, yes, the ratepayers,
Sure.
not the ratepayers, the shareholders would benefit?
In fact, I outline, technically this protection should have been in place when they put the stuff in the ground. My rough justice would have been to go back and calculate how much these assets should have depreciated had they been put in the ground when they should have been put in the ground. And that would be the correct number to put into, in my opinion, rate base. So it can, but it's a very lengthy calculation, and that's I'm not trying to.
Okay, I was just trying to, if there was a more potentially targeted approach that
Yeah.
miuld be considered.
That would be
it's
the
not
target.
necessarily a penalty.
Yeah.
But if I'm hearing you that there may be a benefit for shareholders from this program, and if that's the case,
It is.
would there be a possible remedy that just simply would say there should be no return on any increase in rate base from the meter mitigation program?
Excuse me. I'm just cogitating.
Oh.
It's the company wants to put 100% of the value of these facilities into plant. Mr. Acosta has suggested to put, use the term 50% in plant. And my position is they can put it in plant, but they're going to have to take a 2% hit on.
Okay.
Okay, so there's three different MOs. I really believe rather than Mr. Cross's 50%, the right mechanism would be to find out what really the depreciated value would be had these things been placed in appropriately at the right time. In other words, if a service was put in 1955, you should have put the bollard in there at that time. And so it should be depreciated. And in fact, they want to put plant in today that is problematic intergenerationally with the plant that is currently in service, meaning the mains and the meters. So you may be removing the main, I'm sorry, you may be removing the meter and the regulator and the piping long before you would have depreciated the bollards.
Okay.
Or moved.
I understand your position, and I was just, I guess, trying to get at
Yeah.
from, the point where we replace the, we do all the corrections, okay, that are being suggested.
Yep.
Would there be a change in rate base that benefits the shareholders of the company?
Well, every one of these things is a change in rate base that benefits the shareholder.
Okay.
It's a degree issue. However, I'm more, concerned with the fact that we have all these locations that need to be remedied. And I want to put the pressure on the company to remedy them as soon as possible. I don't want to give them 5 years and 5 years turns into 7 or 8 because the incentive is they'll get their return back when they're finished. And if they can do it in 3 years, they get their return back. But none of the other proposals will give them an incentive, if you will, to rectify these things in a speedier manner.
Okay, well, I think they've agreed to the consent order. So, I mean, that I believe is incentive since they've agreed to that 5-year program.
Right.
But again, would there be another approach, a target approach to any increase in rate base from specifically these increases in rate base such that they would be denied the rate of return? You know, they would be retired so that there would be no profit. Is that a targeted approach that doesn't necessarily penalize the company but also ensures that there's not a financial benefit to the company?
I'm not sure. I focused only on the 3 mechanisms we have in front of us, not another mechanism.
Okay, thank you very much.
Okay.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I was not going to ask questions, but this discussion has piqued my interest a little bit, and I want to make sure I understand your position with regard to these meter replacements. You think the company should be disallowed from collecting full costs? Is that correct?
Essentially, because these things should have been in place quite some time ago on most of these locations. Yeah.
And then you went on in discussion with Commissioner Herman to describe whether or not the company deserves a penalty. And you said you viewed it as a penalty, but they deserved it, I think is what you said. But I need to question that a little bit to make sure I understand what you're saying. You're not suggesting, in other words, is your position based in the financial description or in some civil penalty? What are you saying?
All right. I think the conversation has suggested it's a penalty. I'm trying to suggest that my method is really an incentive for them to speed up their process of fixing these issues. So I understand you believe it to be a penalty. I believe it to be an incentive for them to get the work done in a speedy manner.
Well, I haven't suggested what I believe. I'll
Yeah, okay.
make my mind up later.
But that's kind of my position on it. In other words, I don't see it so much as a penalty. Yes, it financially is a penalty, but it is a way to get them to remediate these issues in a speedy manner. And then give them the return. I believe that, the cost of money witnesses suggest that the company ought to have.
So in your discussion of penalties, then you're talking broadly, generally, not specifically. And conversely, would it be reasonable then to say, to put these full costs into base rates would maybe be a penalty to the ratepayers?
Absolutely correct. That is absolutely correct.
Okay. I just wanted to clarify what we're talking about here. We're not talking about civil penalty. We're talking about the general use of the term.
That is correct. I'm not trying to suggest that the company has to pick up any more civil penalty.
I
No.
think that's a very important distinction. Thank you.
Yeah, no, I'm glad you asked the question.
Good morning. I had a couple of questions about your discussion regarding regulatory lag.
Okay.
We did have a lot of testimony from the company suggesting that they felt that there was a significant impact on them. I'm not sure if you heard the testimony from yesterday from Mr. Marquez.
Unfortunately, I wasn't able to get my hands on it
Okay.
traveling today.
That's fine. Well, he basically testified that I'm paraphrasing, but that the company believed that it was impacted by regulatory lag, and that they were contemplating exploring other means of maybe even expanding the Commission's authority to adopt alternative rate-making options other than the ones we have now, or at least clarifying the Commission's authority regarding rate-making options. So that even goes beyond what's proposed in this rate case today. But in your testimony, you've noted that the company is not, and I'll use your words from page 24 of your direct testimony. I'm looking at line 4, where you basically say the company is not unduly subject to regulatory lag. Unduly subject to regulatory lag. So I wanted to have you explain that a little more to me. Are you suggesting that there is some lag, but it's not enough lag to require that the Commission adopt any other corrective or I'll call it financially assistive measures beyond the ones that exist currently?
Yes, in fact, if you look at page 24, I outlined for you that the company has several riders in its tariff that deal with lag. And so over time, including the Stride rider, deals with really lag. As I said earlier, the principal reason years ago that you had to file rate cases was because you put so much pipe in the ground and had so much plant that you didn't have into plant and you weren't earning on. That was the driver of coming in for a rate case, as opposed to inflationary costs on labor and or materials. Yeah. And so you've taken care of many, many areas of lag with these riders. And in fact, if I look, I don't see that the companies have really trended down or trended outwards in years that they stay out of rate cases. You know, they're still coming in every, 3 years or so. So you would think that if they had all these riders, they would be able to stay out. And it may be a question of growth, the company's growth. So that would be another area that would help reduce lag. I haven't studied what the company's growth is, but that growth would be another reason why lag should be reduced.
So the company, and most of our gas companies in our state has been, as you know, as part of Stride, been working to accelerate pipeline replacement.
Correct.
And so there's some argument from the company that that has been part of the reason for why the lag is more pronounced now than it was before.
Well, they're getting the earnings on it immediately, so I have a hard time believing that that's part of the lag.
All right, thank you.
You're welcome.
Do the parties have any follow-up questions?
Your Honor, I don't have a follow-up question, but I would like to make a statement. You know, this witness has just testified to a variety of things that were not in his direct testimony, well beyond the scope of his testimony. And I think it's completely unfair for the company to be subject to that when the only thing he's done in this case is offered an alternative, what I'll call a penalty mechanism. He can call it something else. He's done no independent analysis of the facts around the meter protection program. He refers to something that happened at Essex decades ago, for which we've had no opportunity to investigate because he's never mentioned it before. So I'd just like to make that statement for the record.
Your Honor, if I could be heard, I just want to point out that those statements were made, as I recall it, all in response to your questions, and I think he was just trying to be assistive with those answers to fully answer the Commission's questions.
Thank you, Ms. Arsky. Mr. Gahagan, your point is noted. The witness did voluntarily provide responses to questions that were outside of the scope of his written testimony. Do the parties have additional questions? Seeing none, Mr. Neal, thank you for being with us today. You are excused.
Thank you very much.
Does the Office of People's Counsel have any additional witnesses?
Thank you, Your Honor. That completes our case.
Thank you. Ms. Romine, if your first witness is available, we'll take him or her.
Yes, we would call Mr. Alvarado.
Thank you.
Well, no, because you told me not to ask any questions. And I said I wanted to ask any questions first.
That's as close to an objection as you really get.
Yeah, I figured.
Confirm under the penalties of perjury that the testimony you have received in the matter now pending is the truth and true.
Good morning, Mr. Alvarado. Could you please identify yourself and your position at the Commission?
Good morning. My name is Juan Carlos Alvarado. I am the Director of the Telecommunications, Gas and Water Division at the Commission.
And did you file direct testimony on September 14th,
I did.
2018? And did you adopt Karen Suckling's direct testimony that was also filed on September 14?
I did.
And did you file surrebuttal testimony on October 26th?
Yes, I did.
Do you have any changes to those documents?
No, I don't.
Your Honor, let me check the list here. I think that would be staff 9?
14, I believe.
Whoops, okay, thank you. We would ask that Mr. Alvarado's direct testimony be marked as Exhibit 14. The adopted testimony of Karen Suckling be marked as 15. And Mr. Alvarado's surrebuttal be marked as 16. And we would ask that those be admitted into the record.
Should we have the witness authenticate those documents first?
Oh, I'm sorry. Those documents were prepared by you?
They were.
Okay, and again, you have no changes to those documents?
No, I don't.
Do any parties have objections? Seeing none, staff exhibits 14, 15, and 16 are moved into evidence.
We would now present Mr. Alvarado for cross-exam.
Thank you, Ms. Zarski.
No questions. Thank you, Your Honor.
Mr. Bain?
No questions, Your Honor.
Ms. Sikora?
No questions.
Do the commissioners have questions of Mr. Alvarado?
I do.
Commissioner Linton.
Thank you.
Start us off.
All right. Good morning, Mr. Alvarado.
Good morning.
I'm moving along pretty fast here. On page 8 of your direct testimony, you make I'm looking at lines 7 through 9 of your direct testimony on page 8. There you note that regulatory lag is, according to your testimony, something that is part of the regulatory process, but unless that it is inordinately high regulatory lag, it's not something that the Commission should normally be concerned of or shouldn't have to address. I was wondering if you could help me to understand how you would define inordinately high regulatory lag.
Well, that's a good question, right? I mean, part of the issue that I was having when I was drafting the testimony is that there's not a lot of data that the company provided to prove their case. And so it's hard for me to tell exactly. The way I would go about this is that I would compare it to the regulatory lag incurred by similar companies in other states, by similar companies in the state, by all, I would go through and do a comprehensive evaluation of what regulatory lag looks like in other states, how that impacts those utilities, and how that compares to the impact it has on BGE in Maryland. Because none of that was presented to us. It was impossible for me to tell, other than them saying, well, we didn't earn our RR, whether regulatory lag was in fact particularly egregious for them or not.
So we know that I think one of the, I can't remember which witness it was now, I'm sure you may even recall, but one of the witnesses compared a number of the companies in their proxy group regarding the types of pipeline replacement assistive programs that existed in different states or with different utility companies.
Right.
And there were different varieties of them, some like Stride, others that were very different. Is there a way to determine if the lag is different for BGE now for gas replacement and just in general for regulatory lag, perhaps going over time, so that since Stride started, for example, and maybe comparing a couple of years before Stride to now, is there a way of looking at that kind of time frame to see if the lag is more pronounced now or more unduly or inordinately high?
Well, we would have to request that the company provide us with a history of their earned return, and then we would compare that to the allowed return, And then we would, if we had enough of a timeline, then we would be able to compare prior to Stride and after the implementation of Stride. And then you would have to probably conduct some sort of regression analysis to rule out all other things. And then what's left is the effect that Stride has on the regulatory lag. I haven't actually done this, so
I'm not suggesting
I'm just, this is the thought process that I go through, and it could possibly be a very complicated thing to do, but it's something that certainly could be attempted.
Okay. We did have, did you hear the testimony from yesterday with a witness case?
I did.
Okay. So the company clearly made it clear that this was a concern of theirs that they were looking to explore, to see if the Commission's statutory authority needed to be expanded, or at least clarified as to what we can do beyond the wording that's existing there currently. You've, in your testimony, starting on page 8, you've done some discussion of the Commission's authority. And what's your thoughts on Mr. Case's testimony from yesterday?
My understanding of, if I recall correctly, what Mr. Case said was that the company's goal was to clarify that the Commission has the authority to, for example, institute forward-looking test years and things like that. My reading, my non-lawyerly reading of the statute is that the Commission has that authority right now, that there's no need for a clarifying. Of course, I'm always for clarifying statements because that makes it very cut and dry, and it makes sure that we're all on the same page and we start from the same position. But my view is that if the Commission finds that there is, for example, inordinate regulatory lag in all of this, and then the Commission says, we should do something about it, they certainly could do that at this point in time. I don't think that the evidence on the record and the analysis presented by BG supports that, but certainly if further analysis was conducted that showed that in a very robust way, then yeah, by all means, I think that that's something that the Commission could look into.
Okay, thank you. Thank you very much, Mr. Chairman.
Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Alvarado, you seem to say that regulatory lag is good generally, or has benefits generally. Is that right?
I would say that there is a purpose for regulatory lag and that it works both ways.
And allowing robust prudency reviews for the costs incurred by a utility are easier to do retrospectively because you can measure things, right?
Correct.
Okay. Do we have things in place that mitigate the effects of regulatory lag in Maryland?
We do, and I think that the company agrees with that. Things like Stride and all those trackers that we use and all those mechanisms certainly allow you to recover the cost quicker and to recover the cost truer, if you want to call it.
Decoupling through bill stabilization adjustments,
for example,
is an example, right? That's a big impact on regulatory lag, I believe.
Yeah, and I don't recall, if you look at page 11 of my direct testimony, I list some examples. I say on line 8, gas utilities in Maryland have made use of tracking mechanisms for commodity cost decoupling mechanisms, such as bill stabilization, Stride, and more frequent rate case filing. So those are some examples that I list.
The company is allowed to earn a rate of return, but they're not guaranteed the ability to, or that return, are they? We don't, in our processes, in our regulation, that's not a guaranteed rate of return.
That's correct.
Are there other things that could affect their ability to earn that rate of return?
I think
besides regulatory lag?
I think absolutely. I mean, and part of the issue that I have with the analysis is that they ascribe the entirety of that to regulatory lag when there can be all kinds of other reasons why this is happening. Positive things like, for example, energy efficiency. Right? There's less consumption of gas or electricity, I guess, in that instance. Will have an impact on the revenues that the company receives. Now, nobody will disagree that energy efficiency is a good thing. So, all these things need to be taken into account, and this is why I say in my response to Commissioner Lin, when you review this, you really have to isolate the effect the regulatory lag itself is having on your ROR, as opposed to just saying, well, we're not earning ROR, it must be regulatory lag. I know that Mr. Case, for example, yesterday said, well, it's my experience, and I look at this, and it's a concern, and I'm not saying that it shouldn't be a concern, but what I'm saying is if it's such a big concern, then a much more sustained, robust review of the effect of regulatory lag needs to be conducted, because the record just doesn't hold it for me.
Okay. Very good. Thank you.
Jeff?
Since we've been talking about this gas meter mitigation program, I did note in your SIR rebuttal pages, I think it's 17, starting on 17, going to 18, you emphatically make the case that what the staff is proposing is not a penalty, but that Mr. Neal's approach would be considered a penalty because the $25,000 has already been assessed as a penalty, and going directly at the rate of return, allowed return, you consider that a penalty. But
Yes.
I think you state that the staff approach is simply, ensuring that customers don't pay for a mistake of the company. Can you expound on that a little bit? I just wanted to understand why.
Well,
what the threshold is of penalty and not penalty.
To me, and the way I have defined a penalty is that it goes above and beyond the cost, the corrective cost, right? So there was a cost to correct the mistake that, and by the way, this is not necessarily exactly what I'm testifying on,
No,
but
what is your testimony?
yeah, there is a cost to correct the mistake that the company made, and I'm not testifying as to whether it was in fact a mistake or not a mistake. You have to ask Mr. Acosta about that. So I take his word that it was a mistake, and so there was a cost to that, and the company should bear that cost. To me, that's not a penalty. That's just fixing your mistake. Anything above and beyond that, to me, is a penalty. So the $25,000 that they paid can be considered a penalty. A hit under ROR can certainly be considered a penalty, and a very, very expensive one, if you ask me. And I don't think it's the appropriate way to institute a penalty for the reasons that I discussed in my testimony. It's not, you don't know exactly what the ultimate penalty is going to be, because it will depend on the revenue on the ultimate revenue that the company earns, and you don't know how long it will go, because the company might come back in a year for a rate case, or they might come back in 5 years for a rate case. In addition to which, there is no direct link that can be tied between this is the mistake that we made, and this is how much it costs us. Like when you have a speeding ticket, okay, well, if I speed over 20 miles per hour, I'm going to get a $100 ticket or whatever it is. But here there wouldn't be that tie. So I really have an issue with giving an ROE or an ROR reduction for something like this. It would really be a very, very harsh penalty in my mind.
Okay, but again, in your judgment, the staff proposal is not a penalty.
Correct.
Okay, thank you.
Do the parties have any follow-up?
Yes, Your Honor, I just have a couple of questions. Going back to page 8 of your direct testimony, I think Mr. Linton addressed it, where you say that we failed to show that the regulatory lag we faced was inconsistent with the purpose of regulatory lag, inordinately high or different from the lag faced by its peers. And I'm certainly, there's definitely treatises about, regulatory lag serving a purpose for efficiency and that. But the part about inordinately high or different from the lag faced by its peer, has that like standard been articulated by this commission?
No, it hasn't.
Has any other commission articulated that standard?
Not that I know of.
Okay. That's all, Your Honor.
Thank you, Mr. Alvarado.
Thank you.
Ms. Romine, please. Oh, Mr. Albert. Please call your next witness.
Yes, Your Honor. We would call Jason Cross.
Mr. Herman was done with the perjury testimony you give in the matter now pending the
Your Honor. Mr. Cross, could you state your position with the Commission, please?
Yes, I'm the Assistant Director of the Telecommunications Division.
And in that capacity, did you prepare testimony in this case?
I did.
Now, do you have before you a document entitled Direct Testimony and Exhibits of Jason A. Cross, which is dated and was pre-filed on September 14th, 2018?
I do.
Your Honor, I would ask that that be marked as Staff Exhibit 17.
So marked.
And do you also have before you a document entitled Sir Rebuttal Testimony of Jason A. Cross, which was dated and pre-filed on October 26th, 2018?
I do.
And Your Honor, I would ask that that be marked Staff Exhibit 18.
So marked.
Were these documents that have been marked 17 and 18 prepared by you?
Yes.
Do you have any corrections to these documents?
I do not.
If you are asked the same questions today that appear in those documents, would your answers be the same?
Yes, they would.
Your Honor, I would move the admission of Staff Exhibits 17 and 18, and I would make the witness available for cross-examination.
Seeing no objections, Staff Exhibits 17 and 18 are moved into evidence. Ms. Sarsky, any questions?
No, thank you, Your Honor.
Mr. Bain?
No questions, Your Honor.
Mr. Krieger?
No questions, Your Honor.
Do the commissioners have questions of Mr. Cross? Mr. Cross, you are excused.
Yes.
Oh, I'm sorry.
So close.
Commissioner Herman, my apologies.
That's okay. Good morning, Mr. Cross.
Good morning.
So it sounds like, with respect to the cost of service study, the only difference is you wanted to stick with the commission precedent, which is a 1 year versus the 5 year average. Is that right?
Yes, at this juncture.
And is there any, you said at this juncture, is there at any time that you think that the commission perhaps should go to the 5 year average?
Well, to be honest with you, I'm agnostic on this. I'm always looking for a way to better a cost of service study. Obviously, there's no one way to do it. If there was, we wouldn't be having this conversation. So insofar as we can find different ways to improve these, that would be to the benefit of all. There was kind of a paucity of data and analysis in this filing, and we would like to explore that further if that's something that the company would like to go forward with. If we were able to look at this more empirically, we would probably decide at that juncture whether or not, but as I stated, I'm agnostic on the point right now. It's just given the data set that I had to work with in this filing, I couldn't support it.
So you're saying that it's possible you could support it in the future if there had been additional data filed, that the 5 year average could be an improvement to the cost service study?
It very well could be. I can't. If you look through the testimony that I presented, I felt that there was not enough data there to draw the conclusions. And it's worth bearing in mind that this is a methodology that the Commission's employed for 30 years. It's probably one of the more vetted methodologies that we have in our toolbox. And it is actually also worth noting that a change in this really could have a ripple effect. We could have other companies doing it, and if nothing else, BG&E oftentimes files an electric and gas case together. And in this case, it's a gas only. So this actually kind of, if we were to really accept this methodology, we would be foreclosing the opportunity for other staff to examine this.
Other commission staff?
Yes, sorry.
And what information was not available that would have assisted you in determining whether or not the 5 year average was appropriate?
Well, and again, this is the company's burden of proof to come and to us and to show that this is a superior methodology. This is not a staff-initiated discussion, insofar as this case goes. The discussion did come out of a recommendation made in a PEPCO case, but it was concerning kind of a different aspect of it. It really wasn't weather-related. It was more with demand and, increased investments, etc. The company came back in with this methodology and essentially promulgated it as a way to smooth out weather effects. So in order to assess this further, we would like to see something, for example, why 5 years, why not 30? We weather normalized to 30 for most of the other, for billing determinants and other aspects of the filing, we weather normalized to 30. Would that be appropriate to use for an NCP allocator? Is 5 years a adequate amount of time? So there's a few things that we could look at, but to be honest with you, again, it's not really staff's burden of proof here.
I understand that. I'm just trying to understand, because it sounds like what you're saying is it's possible that a 5-year average, or that an average might be a good thing going forward, but that there's still some open questions as to what the right time frame might be and the impact on the longer term impacts.
Correct. And again, I understand that this may seem like we're being a little bit cautious about this, but again, it is worth noting that this is something that this methodology has been vetted and accepted by the Commission for the last 30 years. And so going forward with a change, we don't want to just take a change because it may produce a better result. We want to kind of have at least a pretty strong understanding that it will produce a more robust answer, or a more robust set of data from which we can work.
Are you aware of other states that use some form of an average time period?
I have not I did actually look into that a little bit. I did not find much out there. I'd heard of one instance where there was a commission that had used an average. I know that I think there was a commission in Georgia or Alabama that ended up using like a 7-year, but it seemed more like a one-off. So there wasn't a lot of information out there on this type of thing. And plus there is a plethora of methodologies, not just NCP. So this is actually specific to the non-coincident peak methodology. And different commissions use a lot of different cost of service models.
Okay, thank you very much.
No problem.
Any follow-up questions?
No, Mr. Chairman.
Thank you, Mr. Gross.
Thank you.
Mr. Wilson, your next witness.
Yes, staff would call Jennifer Ward.
I do.
Ms. Ward, would you state your position with the Commission, please?
Sure. It's regulatory economist with the Telecommunications, Gas, and Water Division.
And in that capacity, have you prepared testimony for this case?
I have.
And do you have before you a document entitled Direct Testimony and Exhibits of Jennifer Ward, which was dated and pre-filed on September 14th, 2018?
I do.
And does that include exhibits 2 to 5 of your testimony, which were filed separately thereafter on September 18th, 2018?
Yes, it does.
Your Honor, I would ask that the direct testimony as well as the exhibits 2 to 5 that were later filed be marked collectively as Staff Exhibit 19.
So marked.
Do you also have before you a document entitled Rebuttal Testimony of Jennifer Ward, which was dated and pre-filed on October 12th, 2018?
I do.
And do you also have a document entitled Sir Rebuttal Testimony and Exhibit of Jennifer Ward, which was dated and pre-filed October 26, 2018?
I do.
Your Honor, I would ask that the rebuttal testimony of Jennifer Ward be marked as Staff Exhibit 20 and the Sir Rebuttal Testimony as Staff Exhibit 21.
So marked.
Were all three of these documents, including the Exhibits 2 through 5 to your direct testimony, prepared by you?
They were.
Do you have any corrections at this time to
No.
any of these documents?
No.
If you were asked the same questions today that appear in these documents, would your answers be the same?
They would.
Your Honor, with that, I would move the admissions of Ward, Staff Exhibits 19, 20, 21, and offer the witness for cross-examination.
Seeing no objection, those witness exhibits 19, 20, and 21 are moved into evidence. Ms. Sarsky.
Thank you, Your Honor. The Office of People's Counsel has no cross for this witness.
No questions, Your Honor.
Mr. Krieger.
No questions, Mr. Chairman.
Do commissioners have any questions? Commissioner Richard.
Just one on the issue of the customer charge. I just wanted to understand from when staff makes these recommendations, do you look in this case you are now, I guess it's adjusted. In your Sir rebuttal, you went from a $3.75 recommendation to $4 or $14 recommendation. So okay, so you agree to, I guess it's a $1 increase.
Correct.
When you make these recommendations, does staff also consider other state policies like the Empower program and impacts on low income when considering these recommendations on customer charges? Because there's some argument that customer charges do work against the objectives of Empower, and that other studies have shown that it has a disproportionate impact, I should say, on low income. So I'm just interested to know your analysis.
I think that we try to look at everything when we do that, which is always tough. But as far as managing the increase in the customer charge, you want to look at the impact it's going to have on a variety of different usage levels. So historically, I think it was brought up yesterday, the low usage or low income customers have typically had higher usage. And so in my direct testimony, there's a chart showing the impact that my recommendation has on those low income customers as well as every other income or usage levels. But you want to have a customer charge that's going to balance that impact as well as for the company recovering those fixed costs that they do incur. And then balancing the intra-class subsidies. So if you have no customer charge, that's going to create something very dependent on usage. And then that's when you're seeing a lot of the intra-class subsidies. So I think that we try to balance all those considerations when we're making our recommendations for a customer charge.
Okay, thank you.
So I wanted to ask you, Ms. Ward, about Mr. Watkins' testimony that he says the actual customer charge should, the costs are in a range of $11.93 to $12.56. I don't know if you heard that yesterday, and that because of that, he doesn't think the $23.01 and the gas cost of service study is accurate because of the way the costs are bend. Do you have commentary on that?
I think, well, I personally didn't look at the cost of service study or what specifically went into that, but in general, those seemed like costs that are fixed for a customer. They're not going to vary with how much a customer is using, and I think those should be recovered through, some portion of the fixed charge. So I didn't look at exactly the components of the cost of service study, but in general, listening, it those seemed appropriate to include.
So the only difference between your recommendation and the company's recommendation has nothing to do with the calculation
It's just
of the
how
charges.
much of that they are recovering through the
How
fixed
much
charge.
gradualism each of you want to.
Right, and balancing the impact it's going to have on the usage levels, but yes.
Very good, thank you.
Just ask one follow-up to Commissioner O'Donnell. As far as fixed charges, what percentage of fixed charge is based on the meter itself? Is that a significant? You can just give me a ballpark. Is it significant or insignificant?
I'm not sure, but I know where it is.
Okay, and I guess the question I'm going to is now that they have the smart meters, and I think I read another part of the testimony that there are smart meters for gas usage as well. Does that change the equation at all? I mean, is this now less a fixed charge for a single customer and more something that it helps the whole system? It benefits the whole system. And should that change the customer charge impact?
I'm trying to see. I think that what we look at is how much is, based on that cost of service study, what is considered fixed. And so if meters are adding to that, then maybe that should be part of the fixed costs. And I'm not exactly sure what the question is.
Oh, okay. Well, it just seems like it's less, an individual cost for a class and benefits the entire system. So, does that change, I guess, the calculation for the customer charge?
I don't think it changes it specifically for the customer charge because we're still considering so many other things when we're looking at that.
All right, thanks.
Commissioner Linton.
Thank you, Mr. Chairman. Good morning.
Good morning.
Ms. Ward. I'm on page 5 of your rebuttal testimony regarding the Tax Cuts and Job Act.
Okay.
And the treatment of the benefit. The company proposed to amortize it over 5 years to help reduce rate base. Staff has proposed to refund it as a one-time credit. I was curious about witness Mark Manuel's testimony, where he appeared to just say that either one appears to work. You clearly have proposed and recommended that it's a one-time credit, which is consistent with some of our prior decisions. That still is your testimony?
It is. I think that the one-time credit is transparent, direct to customers, and it has a stronger impact, really, that they'd see that.
Okay. Is there any financial benefit to amortizing it over 5 years or using it to reduce rate base? Does it become a little more valuable if we do it that way, or is it just...
I think that ties into some of the accounting questions, but from what I've heard in the testimony in previous days, there's no difference over those 5 years to the customer. It's just that the customer is not going to really see that same impact as if we were to give that back to them at one time.
Thank you.
Ms. Ward, yesterday, witness Jason Manuel noted that the company would have been well within its rights to request a customer charge of upwards of $23, but respecting the concept of gradualism, they are proposing a $15 fixed customer charge. And his testimony largely focused on fairness and inequities caused by the various customer classes. Noting that the fixed charge hasn't been raised in, I believe it was somewhere in the neighborhood of 13 years, how do those arguments resonate with you, the fact that there are intra-class inequities, and if we only adopt staff's recommendation, raising it between 75 cents and a dollar, would the company never be able to get to that $23 or $25 or $30 potential fixed customer charge down the road?
It depends on how the costs change. When you look at those fixed costs, which they're saying is $23 right now, that's changed in a way that's almost like grouped together. So for 2 or so cases, it will stay and then jump up, and then stay, and then jump up and stay. And so we might get to that point. I don't know if that's appropriate. It is difficult to recover all of that because there's a variety of different customers in each class. So a residential class could have somebody with very, very low usage or very high. And so I think that balancing how much is recovered through the fixed charge helps you to manage a pretty diverse class. And so I'm not sure if it'll ever reach that point. It depends on what we see in each case and what's appropriate and how much we're increasing that at once.
Thank you. Do the parties have any follow-up? No. Thank you, Ms. Ward. Why don't we take a 15-minute break at this point, and we'll return with additional staff witnesses. So we will be back on the record 11:35. Mr. Wilson, please call your next witness.
Yes, Your Honor. Staff calls staff witness Jamie Smith.
I do. Good morning, Mr. Smith. Could you describe your job title and just your job duties at the Commission?
I am the Director of the County Investigations Division at the Commission staff.
And in this proceeding, did you prepare direct testimony that was filed on September 14th?
Yes, I did.
And in this proceeding, did you prepare surrebuttal testimony that was filed on October 26th?
I did.
And these documents and testimonies were prepared personally by you, is that correct?
They were.
Do you have any revisions to that testimony?
I do not have any revisions by direct testimony, but I have one revision to my surrebuttal testimony. On page 10, footnote 9, it should be, rather than page 16, it should be page 25. And rather than lines 9 to 12, it should be 20 to 21, and page 26, lines 1 through 6.
Your Honor, I would ask to mark Mr. Smith's direct testimony as Staff Exhibit 22, and Mr. Smith's surrebuttal as Staff Exhibit 23.
So marked.
And we would ask that those be admitted into the record.
Seeing no objection, Staff Exhibit 22 and 23 are moved into evidence.
Now, Ms. Smith, at the November 8th hearing, Mr. Holmes, the witness for BGE, said that reflecting bonus depreciation and rates in this proceeding might violate the normalization requirements of the Internal Revenue Service. And he said that if the IRS makes this determination, this could jeopardize BGE's ability to continue to use accelerated depreciation to reduce their tax liability. And for that reason, Mr. Holmes opposed the staff's proposal that the Commission require BGE to reflect bonus depreciation rates in this proceeding. What is your response?
I agree that staff does not want to cause an IRS normalization violation, so in this proceeding we wish to not continue that recommendation. It will be, if in fact the IRS does accept to use bonus depreciation for the property, and at the end of 2017, in a future proceeding, that bonus depreciation would be reported in rate base, and customers will get a benefit then.
Okay, is there any other testimony you would like to respond to?
That's it.
Your Honor, that we would like to present Mr. Smith for cross-examination.
Thank you.
No questions, Your Honor.
No questions, Your Honor.
No questions.
Do the commissioners have questions for Mr. Smith? Commissioner Herman.
Good morning, Mr. Smith.
Good morning.
With respect to the gain on the sale of real estate, Mr. Holmes suggests that you're deviating from Commission precedent. Is that correct?
I am deviating from the precedent that has been used in the past for BG's cases. In prior cases, the Commission or BG has proposed to start the amortization the month after the gain or loss is known. But my recommendation is consistent with other adjustments that are known. The amount is known and measurable. It's known that that amount is going to be amortized in the rate effective period. So my adjustment is consistent with other adjustments for other adjustments.
Right. Okay. I believe you also suggested the Commission shouldn't include the October numbers. Is that correct?
I only pulled them out because they were estimated, and based on information that was presented yesterday by Mr. Holmes, I haven't had a chance to look through the information yet for the support, but if I go through that and we don't have any exceptions, then I would accept that, and we would file a revised revenue requirement comparison chart to show what our final position is.
And, okay. And finally, do you think an inflation adder might be appropriate if a more conservative number were used?
I'm opposing it entirely, but I think that that would be a better way to come up with a number. Just coming up with a number based on when in the test year seems to be arbitrary. If you used some type of 5-year average number, that seemed like that'd be at least more appropriate.
So is it likely that the CPI could ever be a negative?
I think it could be. I think it could be.
Is it
Probably not likely.
Not likely. Okay. All right. Thank you very much.
Commissioner O'Donnell.
Real quickly, on SERP.
Yes.
So the commission has disallowed 100% in 2 other cases. Is your position on that to go to 0% allowance for SERP based on consistency with other utilities and the judgment of the commission in those other cases?
It is.
Okay. And there's nothing different in this case than those other cases where there's some documentation of benefit to the customers or retention, some justification for retention purposes.
No, BG did not include anything in their support to show the justification to include those amounts.
Very good. Thank you.
Do the parties have questions based on Commissioner O'Donnell or Herman's questioning? Thank you, Mr. Smith.
Thank you.
Staff present our next witness, Carlos Acosta.
Thank you. You may be seated.
Good morning, Mr. Acosta.
Good morning.
Do you have in front of you a document entitled Direct Testimony and Exhibits of Carlos A. Acosta, consisting of 25 pages and 10 exhibits?
Yes, I do have.
And do you also have in front of you a document entitled Surrebuttal Testimony and Exhibits of Carlos A. Acosta, consisting of 18 pages and 2 exhibits?
Yes, I do.
And were these testimonies prepared by you or under your direction?
Yes.
Can I ask you to please speak up a little bit so everyone can hear?
All right. Yes.
Thank you. If I were to ask you, do you have any changes or additions to these testimonies?
No, at this point.
If I were to ask you these same questions today, would your answers be the same?
Yes.
Okay, thank you. Your Honor, I move admission of the direct testimony and exhibits as Exhibit 24
So marked as 24.
and the surrebuttal testimony and exhibits as Exhibit 25.
So rebuttal and exhibits marked as Staff Exhibit 25. Seeing no objection, Staff Exhibits 24 and 25 are moved into evidence.
Thank you, Your Honor, and the witness is available for cross-examination.
Thank you, Your Honor. Just one or two questions. Good morning, Mr. Acosta.
Good morning.
As I understand your direct testimony, you gave a summary of the background of the notice of proposed violation. Is that correct?
That's correct.
Yeah. And that notice of probable violation was issued by the Engineering Division of the Commission, correct?
That's correct.
And it resulted in a civil penalty, as I understand it.
That is correct.
And as part of the response back from BGE, there were also some additional representations and promises made to the Commission related to, for example, outreach to affected communities. Do you recall that?
It's part of the plan, sí, yes.
Right. I just have some questions about process issue as it relates to not only this notice of proposed violation with BG&E, but possible others even related to other companies. If a situation arises, such as what happened in this instance, as part of the Commission Engineering's division process, is there notice given to anyone else other than the actual utility that there might be some civil violation or civil penalty that might be coming up? For example, is there notice given on the Commission website or to other interested parties at the time?
No, that I know. We send a letter to the operator and they had to answer.
Right. And after, say, a company, as in this instance, agrees to some form of either penalty or remediation effort, in this instance, there was a communication component that BG&E sought to undertake with affected communities, I think with homeowners associations, with home builders, and possibly with some state and local officials. Is there ever a process, to your knowledge, where that outreach also includes some other affected stakeholders, for example, representatives of residential customers in the state?
No, that will be on BG&E.
Okay. So no notice is given directly by the Commission, for example, to the Office of People's Counsel that there might be this safety issue that is being remediated and that customers are being contacted for that remediation plan?
No, we as an engineering division, we don't do that.
Okay.
Perhaps there is other areas, but
Right.
I
I just wanted to understand the process from the engineering division perspective. And I think, Your Honor, with that, that does conclude my cross with Mr. Acosta. Thank you, Mr. Acosta.
You're welcome.
Mr. Bain.
Yes, just one or two questions, Your Honor. In your direct testimony, you discussed the investigation into the incident at Sleepy Horse Lane. Do you know whether the BG&E work in question, the locating and installation of the meter, was conducted by BG&E in-house staff or by contractors?
I don't know specifically for this incident who was the installer for the meter.
Okay, that's all I have, Your Honor.
Thank you, Mr. Bain. The company.
Thank you, Mr. Chairman. Good morning, Mr. Acosta.
Good morning, sir.
Great to see you again. I also have some questions for you about the much-discussed gas meter relocation program and the incident at Sleepy Horse Lane.
Perfect.
Your recommendations in this case are based on your position that the company failed to comply with federal pipeline safety regulations that were in place at the time the houses were constructed and the meters were installed by the company. Is that correct?
Yes.
And the federal regulation that you're referring to, I think, is set forth on page 20 of your direct testimony, starting at line 12, 49 CFR 192, 353A and C. Is that correct?
That's correct.
So there's a lot of stuff in these two provisions here. I just want to make it clear here. I want to get your testimony on this. When you claim that BG violated the federal regulations, are you claiming that the violation had to do with the protection from damage requirement, the location in a ventilated space requirement, or the location not being less than 3 feet from any source of ignition requirement? Which one of those?
The three of them.
All three of them? Okay. So I want to talk about each of those issues then. Let's start with ventilation, which has been discussed at some length in this proceeding so far. On the ventilation issue, you claim in your surrebuttal testimony at page 10, line 10. Tell me when you get there, sir.
And there.
Okay, great. Yeah, you claim there that the garage at issue at Sleepy Horse Lane was not ventilated, correct?
That's correct.
And you state on line 11 there that if the garage had been ventilated, the gas would have been, or would have had a means to escape, correct?
That is correct.
Okay, Mr. Acosta, do you happen to have up there at on the stand with you a copy of Staff Exhibit 5? If not, I can provide you one.
Mr. Costa,
I'm sorry.
he's
Oh, yeah.
providing you
Perfect.
Staff Exhibit 5.
I got it.
And Mr. Acosta, this was marked and entered into evidence, I think, last Friday. This is a copy of the PSC Engineering Division's Pipeline Incident Investigation Report for the Sleepy Horse Lane incident. Do you recognize this document?
Yes, sir.
Is that your signature at the bottom of each page of this report?
Yes, it is.
Okay, so is it fair to say that you have a lot of familiarity with what happened in this particular incident?
Yes.
Okay, so this incident took place at 12218 Sleepy Horse Lane, correct?
Yes, that's correct.
And so on page 6 of the Staff Exhibit 5, I'd like to direct your attention up there to the event log. And specifically the first entry there, 6:45 p.m. Are you there?
Yes.
And that states, at 6:45 p.m., a resident of 12220 Sleepy Horse Lane called BGE to report an odor of gas. So 12220, that would be a neighbor's house, correct?
That's correct.
Okay, so clearly then, Mr. Acosta, there was gas escaping from the garage, correct? Because the neighbor was not in the garage and was able to smell the gas, right?
That's correct.
Okay. I'd also like to direct your attention to Staff Exhibit 6. And again, I can provide a copy of that if you do not have that. Thank you. And this, again, was identified and entered into evidence last week. This is a copy of the February 24th, 2016 NOPV that was issued to BG. Do you recognize this document?
Yes, sir.
And I'd like to direct your attention to the bottom of the second page and the top of the third page. The document doesn't have page numbers, so you just have to flip over. These are the paragraphs starting with according to the investigation, and then it goes up to the next page and has 2 other paragraphs.
Mm-hmm.
I don't see any mention in here about a ventilation issue. Do you, Mr. Acosta?
No, there is no.
Okay, thank you. And then down in the proposed compliance order section, just down below, again, I don't see any mention of the word ventilation or really any indication that there was that the engineering division came to the conclusion after the investigation that there was a ventilation problem with this particular site. Do you see anything in the proposed compliance order to that regard?
No, there is no the word ventilation in there.
In the particular, that paragraph 2, within 120 days, BG shall provide protection for the remaining meters in the Clary's Chase development where the explosion took place. Clary's Chase, that's where the Sleepy Horse Lane property is located?
Yes.
And again, in that paragraph, I don't see anything about moving the meters because of a ventilation problem. Is that correct?
We didn't ask to move the meters.
In fact, down in paragraph 3 there, it suggests, doesn't it, that staff would be okay with meters actually remaining inside?
Do you see in paragraph 3 that is said in accordance with 49 CFR 192-353?
Yes.
We are addressing this regulation. If you take a look at the regulations, are in the first page, 49 CFR 192-353C A and C, and these regulations should be followed by BG&E when they install or they go back to do the protection for the meters. In there, you can take a look, they are talking about the ventilation. That's why we address these regulations.
I understand that, sir, but in paragraph 3 there, you say, within 30 days, BG shall describe the methodology that it will implement to ensure that every new and renovated gas meter inside and outside of buildings is installed with appropriate protection against vehicular and other damages in accordance with 49 CFR 192-353. Again, there's no mention there about moving meters outside because of ventilation concern, correct?
We didn't ask for move the meters. You should, as a BG&E, should install these meters in a ventilated space.
Okay, thank you, sir. I want to move on to the clearance issue, 3 feet of clearance. Now, I believe your position in your testimony is that because the car at this property transited in and out of that garage at a distance closer than 3 feet to the meter, and because that car was, in your view, an ignition source, that this meant that the meter placement was in violation of the federal standards. Is that a summary of your position on that particular point?
It's less than 3 feet.
I'm sorry.
It is less than 3 feet. The meter was installed in less than 3 feet where the passage of the car was going in and out.
Mr. Acosta, how many instances can you tell me about where a vehicle acted as an ignition source for a BGE meter installed inside of a garage?
I never saw something like that.
Okay, you never saw anything like that on BGE?
In BG&E, no.
Okay, what about in the state of Maryland? Have you ever seen an incident like that?
No.
What about the rest of the country? Have you ever heard of an incident like that?
No.
Okay, and in fact, in this case, the vehicle was not actually the ignition source in this particular event, correct?
That's correct.
Okay. I want to move on to the damage protection part of the regulations. On the damage protection issue, your testimony is that the meter was not adequately protected, correct?
That's correct.
And you state that the gas meter was not protected by what we call the wing wall in this townhouse, correct? This townhouse where the incident took place, it was constructed back in 1994, correct?
That's correct.
So, Mr. Acosta, between 1994 and 2015, when this incident took place, basically 21 years passed by without any vehicular damage occurring to that gas meter of which you are aware, correct?
That's correct.
Okay. BGE, they have other gas meters on their system that are located inside, correct?
Yes.
And some of them are located inside garages, correct?
When there is ventilated garages, yes.
And in this case, the Sleepy Horse Lane incident, the customer had actually backed out of the garage with the car door open. Is that correct?
That's correct.
Mr. Acosta, you're not aware of this sort of incident ever occurring on BGE system before where a car backing out of a garage with its door open strikes gas equipment inside of garage, are you?
No.
What about in the state of Maryland? Are you
No.
aware of any situation like that? What about the rest of the country?
No.
And really here, the customer didn't actually hit the meter, right? She hit the piping on the customer side of the meter. Is that your understanding?
She hit the side of the meter, but she damaged part of your meter, to your pipe, who was close to the wall.
Understood, but the actual strike was between her vehicle door and the customer's side gas piping, correct?
It is very difficult to determine that because the car was hit on the left side of the meter.
I'm sorry, I didn't understand that.
The
last
car
time.
hit the meter
Mhm.
on the left side of the meter. It's very difficult to see which part of the meter was hit.
Okay, but are you testifying today that you believe that the car door actually struck the meter itself?
I didn't see that.
I understand. Well, you weren't at this. Obviously, you weren't at the scene when the incident took place.
I was not there.
So you're not clear exactly what the car door struck.
The meter was in the way of the car, so the door hit one side of the meter. Now you are telling me that the meter hit the piping.
I'm asking you if it's your understanding if the car door hit the piping or the meter.
The meter.
Okay. Can you turn to page 8 of your rebuttal testimony? Are you there, sir?
Yes, I am.
And I'm looking at a picture there, picture number 1. Do you see that?
Yes.
This picture was discussed at some length last Friday. The damage, well, first of all, you see there's a lot of damage there in that picture, correct?
That's true.
That damage was caused by the gas explosion, right? Not the vehicle that the resident owned, right?
That's right.
Now, Mr. Acosta, in your testimony, you mentioned that BG did not meet the requirements of either the federal pipeline safety standard regulations at the time the meters were installed or the current federal pipeline safety regulations. Did I see that correctly in your testimony?
I'm sorry, can you say that again?
In your testimony, you state that BGE violated not only the federal regulations in place at the time the meter was installed at the Sleepy Horse Lane address, but also the current federal pipeline safety regulations.
Again, I guess I don't understand the question because the regulations vary a little bit since that time.
Okay, well, let me see if I can clear this up. Let's go to page 19 of your direct testimony. Are you there, sir?
Yes, I am.
And now I'm looking down on line 20. And you state, as in a response to the question, did BG meet the requirements of the federal safety regulations at the time it installed the meters? You say no. BG did not meet the requirements of either the federal pipeline safety regulations at the time the meters were installed or the current federal pipeline safety regulations. Did I read that correctly?
That's correct.
Okay, so that was what my question was. Are you claiming that BGE is in violation of the current federal regulations?
BG&E installed this meter in 1994, and they install according to the regulations. What we addressed in the letter was the current regulations, that they are more stringent than the previous regulation.
Okay, but again, it's a simple question, Mr. Acosta. I just want to know, are you claiming that BG is currently in violation of the federal pipeline safety standards?
That's right.
You are, okay. So then, if that's the case, then it would appear that you're aware that in 2003, that PHMSA changed the wording in the federal pipeline safety regulations?
I am aware.
You are, okay. And I just want to make sure that we're on the same page here with what was actually changed. If you look on page 19, again on 19 of your direct testimony, and you have the current version of the federal regulations there, is that correct?
Yes.
And if I do a comparison between the two, it looks to me that the change was made in subsection A, where the following language was added. quote, including if installed outside a building, vehicular damage that may be anticipated. However, the upstream regulator in a series may be buried.
That's correct.
Okay, so it appears then that when PHMSA was changing that regulation, that they felt it was necessary to include specific language regarding anticipatable damage from outside meters, but they declined to include similar language for indoor meters. Is that correct?
They didn't decline anything. they increased the regulation. You are telling me that they didn't do this for inside meters? What regulation said is each meter and service regulator, whether inside or outside a building, must be installed in a readily accessible location and be protected for corrosion and other damage. So, with that, the regulations are not canceling what you are telling me now.
Well, I wasn't suggesting they were canceling. My question was a little simpler than that. I was just asking you if when PHMSA added the language, specifically relating to vehicular damage, it only pertained to outdoor meters, correct? Not indoor meters.
That's correct.
Okay, thank you. And I'd like to go back to the NOPV, which is Staff Exhibit 6. You have that, sir?
Mm-hmm.
Now, you state on page 15 of your rebuttal testimony that of the 4 different response options to an NOPV, BG agreed to the consent order option. Is that correct?
That's correct.
Now, I notice here in the NOPV, there's a footnote down there. It says footnote 1. If you look above, though, it looks like it, I don't know, maybe it should have said footnote 3. It's after the footnote appears after the request the execution of a consent order option. Do you see that, sir?
There's a footnote, yes. Number 3.
Okay, so that's what I'm referring to, that footnote. Now, that states that a consent order is a document in which the company agrees that the violations have occurred and they agree to certain penalties or required compliance. Did I read that correct?
Yes.
But as you point out in your rebuttal testimony at page 15, line 19, the COMAR official definition of consent order states that it is, quote, a document executed jointly by the engineering division and a gas company or gas meter.
Where are you at?
I'm page 15, line 19 of your rebuttal. I'm sorry, I should have waited till you got there.
Okay. What line?
19. In response to the question, what is a consent order, you state that COMAR defines a consent order as a, quote, document executed jointly by the engineering division and a gas company or gas master meter operator under COMAR 2057-0207 for the disposition of a case. Did I read that correctly?
Yes, sir.
Mr. Chairman, can I just ask, I'm lost on where we are. Did you say rebuttal?
Rebuttal,
Yes.
page 15,
Oh, 15. I thought he said 19.
No,
line
that's right.
19 through 21.
Okay,
It's line 19.
thank you.
I'm sorry, I should have waited. I was going too fast.
Thank you, I'm
Are you
sorry.
there? Okay.
I'm with you, yes.
All right, so I'm sorry, Mr. Acosta. Did I read that correctly, your
Yes, sir.
testimony? Okay, so then you would agree then there's no language in the official COMAR definition of consent order that suggests that by signing one of these documents that a party is agreeing that a violation occurred, correct?
Do you see this next question?
Yes?
It said, does the consent order indicate that the violation have occurred? The description. Does the consent order indicate that the violations have occurred? The answer is the description of the consent order response option in the standard PSC Engineering Division standard NOPV letter and in the NOPV letter the BG&E dated February 24, 2016 indicated that the consent order is a document executed jointly by you, gas operator, and the Commission's engineering division, in which you, the gas operator, agree that the violation have occurred and agree that the certain penalties or require compliance. So, in the next question, we are quoting what the note or the footnote you are telling me here. And this is our standard letter that you agree to sign the consent order.
I understand everything you just said, and that was the purpose of my prior question, to ask you about the footnote in the standard PSC NOPV letter. But my last question had to do with the official COMAR definition of consent order. That definition does not state anywhere in there, does it, sir, that agreeing to a consent order acknowledges any violation by the party, does it?
I don't have the COMAR with me. If
Sir, this is your testimony. I'm just reading
I
what you
don't
put.
have the COMAR with me, it might be another place that they put this footnote from COMAR.
Okay, well, we can make that subject to check, but I'm asking you about the language that you quoted here in your testimony.
Well, in the testimony, it doesn't say this. Yes.
Okay.
However, in the next question, we quoted that.
You quote your letter. Yes, I understand. Mr. Acosta, are you aware, do other Maryland gas utilities have gas meters located indoors?
Located where?
Indoors?
Yes.
And do they have gas meters located in garages?
Some of them, yes.
Okay. And to your knowledge, has the PSC Engineering Division ever issued any other NOPVs to the other Maryland gas utilities for violations of meter placement similar to the kind that you're attributing to BGE in this particular case?
No, because the operators should install these regulators or these meters inside the door when it's ventilated areas.
But you're not aware of any other NOPVs for meter placement? Last question, Mr. Acosta. Would you agree that if the company was not in violation of the federal standards, that it should be permitted to recover all its costs associated with the meter mitigation program?
I'm sorry. Can you repeat that?
If it was determined that the company was not in violation of the federal regulatory standards, would you agree that the company should be able to recover its costs associated with the meter mitigation program?
The company accepted that they are in violation.
That's not the question I asked you, sir. It was a very simple question. I just want to know if the company was found to not violate the standards, would, in your opinion, it be acceptable for the company to recover all of the costs associated with this meter mitigation program?
If they did not violate this, I guess yes.
Okay. In fact, in BGE's response to the NOPV, which was Staff Exhibit 7, I also have a copy of that here.
Thank you.
Do you recall this document, Mr. Acosta, the March 31st?
Yes, sir.
Okay, so you're familiar with this document. Isn't it true, Mr. Acosta, that the company denied that it was in violation of the federal standards that were cited in the NOPV, correct?
It's why they failed at that time.
I'm sorry, I didn't understand that.
They felt that they were under compliance.
They felt that they were in compliance.
Yeah.
Okay, thank you. That's all the questions I had, Mr. Chairman.
Thank you, Mr. Herson. Ms. Romine, any redirect?
I do, just briefly, Your Honor. If I could approach with an exhibit.
Please.
Your Honor, if I could have the exhibit that I just handed out, which is entitled OSHA Fact Sheet, marked for identification as Staff Exhibit 26, please.
So marked.
So, Mr. Acosta, I just have provided you with a document entitled OSHA Fact Sheet. Do you have that in front of you?
Yes. Yes, I do.
Have you had an opportunity to review this exhibit?
Yes.
And can you briefly summarize for us today what this fact sheet states?
Yeah, there is so many accidents that happen due to the combustion engines that they were source of ignition in job workplaces, and they cite this thing that they say that internal combustion engines, whether fueled by gasoline, diesel, propane, natural gas, or other fuels, can act as ignition sources. Examples, there is various examples in here, and in the second bullet they said mobile equipment or transport such as mobile equipment or transports such as vans, trucks, forklifts, cranes, or servicing equipment, drilling rigs, and others. So there is so many investigation about the explosions or fires by OSHA that they demonstrate that a car is a source of ignition.
Okay. That's all the questions I have, Your Honor. Thank you. Could I have Exhibit 26 admitted into evidence, please?
Any objection?
Your Honor, I'm not going to object to the introduction of this, but I will point out that this is a OSHA fact sheet. It states internal combustion engines present an ignition hazard when used in facilities processing flammable liquids and gases. This incident we're talking about here today is a garage. It's certainly not a facility processing flammable liquids and gases, but I'm not going to object to the introduction of it.
Your Honor, I would just state that the document speaks for itself, for what it says.
Thank you. Noting Mr. Hurston's statement, staff 26 is moved into evidence.
I have no further questions, Your Honor.
Thank you. Mr. Acosta, what was the source of ignition in the Sleepy Horse incident?
We don't know what was the source of ignition.
Do commissioners have questions? Commissioner O'Donnell.
Mr. Acosta, have you heard, have you watched the proceedings go on the last several days?
No, I was in a trip for training. Unfortunately, I couldn't see this.
I don't blame you. I talked to some of the other witnesses about what happened in with the NiSource company up in Massachusetts, and I know Engineering Division has put out some inquiries to the companies so that they can start putting some bounds around this. Do you know where that process is in the Engineering Division with regard to low pressure systems in the Maryland Utilities service territories?
No, I am not aware of that.
Not aware of it.
Maybe you have to ask another person.
Fair enough. All right. Thank you.
But
go ahead.
About Massachusetts, you said?
Yeah, so there was a lot of explosions back in September in Massachusetts due to an overpressurization of a low-pressure gas distribution system. And I think our engineering division is doing some inquiries with our utilities, and I was just asking about what the status of that is.
No, I am not aware to that inquiries.
Fair enough. Thank you.
Mm-hmm.
Good afternoon, Mr.
Good afternoon.
Acosta. Just wanted to just follow up on a question I asked Mr. Alvarado about the purpose of I guess, your recommendation on to disallow some of the costs. The $25,000 fine, that was intended to be the penalty. Is that correct?
That's a penalty.
And in Mr. Alvarado's testimony, he basically summed up that this was not meant to be a penalty, or I'm sorry, the costs or disallowance of costs was not meant to be a penalty, but simply to ensure the customers didn't pay for the company's mistake. Is that correct? Is that how you intended?
It's not real a
Described, I
penalty.
guess, your recommendation.
The company should install protections at the time that they install the meters. They didn't. So now, because of the NOPV that we sent to the company, they are doing this program to mitigate that situation. So for that work, there is some cost that they could expend that cost at the first time in materials, for example. But we are not agreeing that we have to pay for the second trip. That's why we put a percentage, the 50%, which is a reasonable approximate, so that the company can work and keep the homes safe. The main point of this NOPV was the safety of the homes, because with no protection of the meter and meter installed in no ventilated areas, will end in more situations like that happen in Sleepy Horse. We don't want that. We want everybody to be safe. That's why we address the situation with BG&E, and they accept that this has to be done. So, but it's part of their job that they didn't finish at the first time.
Okay, but it wasn't intended to be
A fine, no.
a fine or a penalty. Okay, and then I'm just looking right now at your direct testimony on comparing Table 6 and Table 7. I guess on page 22 and 23. So this lays out the cost of the program to date. Is that correct?
Yes.
And then I guess we're to understand that there are a number of additional mitigation projects to come. So this, whatever I guess we decide now, will be somewhat precedential in what we do in the future.
Yes, because this situation had to be fixed. So we don't want more situation happen again in our state.
Okay, and then looking at the various percentages, how did you arrive? Now I'm looking at table number 7. Labor 50%, contractor 50%, 100% for materials. How did you arrive? I think you
it is very
touched on it a minute ago, but
yeah, it's very difficult.
Detail.
It's very difficult to assess how much it will be, because we have to have the cost from everyone and how much it will be for different kind of protection that they will do, or they will remove the meters and put the meters outside. So we have a discussion in engineering division, and we agree that this could be a good number to suggest you, the commission, to accept if BG&E is trying to recover this, because there was work that was not done at the beginning, and it has to be finished, protection-wise.
Okay, and since if there are 5,000 to 8,000 more of these projects to come in the future, did the staff discuss that this would be potentially a pretty significant cost to the company?
Yes, it will be, but new installations, for example, should be done according to the regulations. So if they had to replace this in the future, maybe they will have to ask again to put this in the rate cases. I don't know.
They come back, okay. Did the staff discuss any other, I guess, options that might benefit ratepayers? In other words, ways to offset some of the potential costs to ratepayers for this this violation, is what you're calling it, that the company would have to mitigate. Did you consider maybe less costly options to the shareholders of the company, or was this the only option that you?
This is the
would be
only
best?
option that we have an agreement to put in my testimony. However, it's up to you. The cheaper cost will be disallowed the 100%, but is in euro.
So 100% or potentially less.
Potentially
In
less
other
is
words,
possible. Yeah,
you know,
maybe we
that's why
can.
I asked the question. Some of these costs potentially could increase rate base. Is that correct?
That's correct.
And in that case, that would potentially, be a benefit to the shareholders. Okay, so is that something that the staff considered?
Yeah, maybe we can take a look a little bit more deep, and maybe it could vary in the percentage that we recommend.
Okay. All right, no more questions. Thank you.
Thank you, sir.
Commissioner Linton. Thank you, Mr. Chairman. Good afternoon.
Good afternoon, sir.
That clock's correct now. I'm looking at the notice of probable violation. It's Staff Exhibit 6. Under the proposed compliance order section, there are 3 items there that this engineering division is suggesting the staff, or excuse me, that the company should proceed with. At the time that this was drafted, was there any discussion, and at the time it was drafted and then submitted to the company, was there any discussion at that point about the potential costs or any concern about what the costs would be?
No, we didn't have a discussion about the cost because it's BG&E's lack of compliance that forced us to ask them to remediate the situation. So we were no further to think that they want to come back to fight for this, because the consent order was the agreement that they have, that they had to follow the compliance order and pay the fine. So with that consent order, that we thought that it was a closed deal.
Okay, so in Staff Exhibit 7, when the company responded with their response to the NOPV, that included a description of what they would do to create this meter mitigation program. Was there any concern or thought at that point?
No, because if you see in the second page of the consent order, in the third paragraph, the second phrase, he said, nevertheless, BG&E agrees that the items set forth in your proposed compliance order are worthwhile and desirable measures that will further serve to protect customers. So BG&E is agreeing with this compliance order. At this point, BG&E is agreeing that they were not in compliance with the regulations. Is their consent order.
So was the staff satisfied with that response? Were you surprised by it? Can
Yeah.
you characterize what the staff's response was?
Yeah, even though in some part of the letter they believe that they are in compliance, we are demonstrating them with the NOPV that they didn't follow the regulations, and they are accepting this while they are replacing or they are installing the protection to the meters. So if I was following the regulations, why I had to do this now? If BG&E at the first place follow the regulations, why they have to do these programs? And they agree with our proposed compliance order, and why they pay the fine.
So it sounds as though you were expecting, perhaps, is it appropriate to say that you were expecting that BGE would appeal or refuse?
No,
or
at this
anything of
point
that sort?
we were not expecting this. Okay. In 2016, March 31st, we have a conversation, and we never expect they were putting this in the rate case.
So for the type of mitigation that the company was going to pursue, the installation of bollards, moving meters to outside from inside of garages, did the Commission Engineering Division give any direction to the company as to the type of mitigation? Did you tell them that this is what must be done, or was there any kind of direction of that sort?
The direction is in the NOPV. You see the third page in proposed compliance order. There is the 3 items that we address that the company should be doing. And they prepare a plan to address all these compliance orders. So if they are accepting that they have to do this, I don't know why at this point they are arguing that they follow the regulations. I don't really understand.
So the plan that the company provided, which included a couple of different options, installing bollards or, well, that's not actually in their letter, but that's what they've been doing, is installing bollards or removing meters. The engineering division found that to be in compliance or under the terms of the agreement.
Yeah, I believe that they are filing to the engineering division every year how many of those they evaluate and they did the protection in these meters. Why we ask for 5 years is because the cycle for the leak survey is every 5 years, and in 5 years all the meters could be seen by the leak surveyor and could be evaluated if they are with protection or without protection, or if these are in ventilated spaces or not.
Okay. All right. Thank you, Mr.
Quick follow-up.
You're welcome.
Just a follow-up, Mr. Acosta, to Commissioner Linton's question. Are you saying that if they are in compliance, this work is unnecessary? Why are we doing it?
No, I am saying if they are in compliance, why they are doing this?
Right. That's what I just said.
Why they accept the whole compliance order? I don't understand.
So it would be an unnecessary expense if they were in compliance.
Yeah, but
why would you spend money and try to put it in rate base if they were in compliance?
that is my question also.
All right. Okay, just making sure I understood. Thank you.
Thank you.
So I'll finish out this subject and then move on to the leak repair and repair costs. But so when BGE filed its response, you indicated that you were somewhat surprised that they didn't agree that there was a violation. Did I hear that right?
I'm sorry. What did you say
When
first?
BGE filed its response to the notice of potential violation,
Yeah.
you were surprised that they said that they weren't in violation. Is that right?
Yeah. They feel in the letter in some place they say that we are following the
Right.
regulations.
Right.
But
And that was a surprise to you?
yeah.
Okay.
But further down in the second page, they tell also, BG&E agrees that the item set for in your proposed compliance order agrees that the items set for in your proposed compliance order are worldwide and desirable measures that will further serve the protect customers. So they're agreeing with us.
Well, I think that's debatable, but I just wanted to understand that you acknowledged and were surprised by the fact that BGE thought that they were in compliance. Is that correct?
That's correct.
Okay. So did the staff file a complaint against BGE to formalize your concern that they were not in compliance?
No, we don't, because as our NOPV said, the response from the operator could be a consent order, and basically in the note that Mr. Horson was telling me about the NOPV, it said that they are agree with the compliance. So they could go further and take another option for the compliance order. It said object to the proposed compliance order and submit written explanation, information, or other materials in answer to the allegations in the notice. They could do that. They didn't do that.
Right. I understand that. I'm just trying to I'm going past that. I'm going to the staff's reaction, and the staff didn't file a complaint. Is
We
that right?
didn't feel that we had to
Okay.
do any more actions about that.
Okay, I'm good. A couple of days ago, I asked some questions about these leak repair costs and the number of leaks, and I'm not exactly sure what your testimony is. Are you testifying that the number of leaks should be declining, that they are declining? It's a little unclear because these charts, frankly, are, some of them go up, some of them go down, so I'm unclear as to what you're trying to say with respect to the leak.
There is a reduction of leaks since 2016 in 2017. And to repair the leaks, if there is a reduction of leaks, the cost will be reduced also. But there is less leaks, but they pay more money. And that's the thing that I address in my testimony.
You're saying there are fewer leaks than there were
They were in 2016, for
in
example.
60, but they're, well, let's see.
But the cost was
But-
higher.
The number of leaks repaired in 16 is higher than 17, and then, but the test year is lower, right? I'm looking on page 15 of your direct testimony. Graph 1,
Yes.
it shows the leaks are higher in 16, lower in 17, and even lower in the test year. Right?
It is
So did BGE make some sort of adjustment to increase it above the test year?
I don't know.
You don't know. Okay. Okay, that's all I had. Thank you very much.
But can I add one more thing? You see the 2016, 2017, and the test year, the tendency is going down.
Right?
So number of leaks are reducing every year. So that's a good indication.
So are you proposing an adjustment to reduce the test year number of leaks? I'm just kind of confused as to what it is you're proposing.
No, I guess what I'm putting in this table is the number of leaks that they are presenting every year, even the test year. So just to visualize what it is about. I am not proposing anything about that.
Oh,
I am
okay.
just telling the commission that the leaks are going down.
Leaks are going down. Okay. All right. Thank you.
However, the costs are going up.
Costs are going up. I got
I'm-
that. That one I got. Okay. All right. Thank you very much.
You're welcome.
Do the parties have questions of the commissioners? Questions?
Yeah, I think I have a couple follow-up questions, Mr. Chairman. Mr. Acosta, based on your conversation with Commissioner Linton, I'm just wondering here, are you stating then that if a company like BGE agrees that a number of recommendations in a proposed compliance order, if the company agrees with that, that means that somehow they can't dispute the imposition of a penalty or that they were in violation of the standards? Are those mutually exclusive in your mind?
I don't know about that question. I think that you should ask the legal person in my office. However, what I am saying is, if you agree that you have to comply with these things because it's a compliance order, that means that you didn't comply.
Well, to be clear, I mean, we didn't state that we have to comply. The
But
language,
you say, I agree.
the language in the letter states we agree that the items set forth in your proposed compliance order are worthwhile and desirable measures that will further serve to protect customers. Did I read that right?
Yeah.
Yeah,
But
we're
why
not-
you do that?
Hmm?
Why you do that?
Mr. Acosta, let's wait for a question from Mr. Herson.
I'm sorry.
Okay, I was just confused because your testimony makes it sound like we can't agree to something that the staff proposes and at the same time challenge that we violated some federal standard.
Mr. Herson, I didn't hear a question there.
Is that correct? All right, I think I've made my point, Mr. Chairman. A couple other quick questions. Mr. Acosta, is moving meters outside, does that make them easier to inspect?
Yes.
And does it make it easier, if you're moving a meter outside, does it make it easier for first responders to turn off the gas?
Your Honor, these are gone beyond what the commission asked.
Yeah, Mr. Herson, I don't recall a commissioner inquiring about the placement of meters outside.
Well, Mr. Acosta was discussing about how we had agreed that some of the measures were worthwhile, but suggesting we were still in violation of the standards. I was just exploring with him why the company might think these measures were worthwhile.
Do you have another question, Mr. Herson?
Are you aware, Mr. Acosta, BG standards, they've evolved, right, to have a preference for meters being placed outdoors now? Is that correct?
Same objection.
Sustained.
Okay, one moment, Mr. Chairman. No, we're done, Your Honor. Thank you.
Thank you. Any other questions? Thank you, Mr. Acosta. You are excused.
Thank you, sir.
Does staff have any additional witnesses?
No, Your Honor, that is staff's case.
Thank you. Before we conclude for today, do the parties have any additional matters to bring before the commission? Seeing none, we will reconvene tomorrow. Mr. Gagan, anything final from the
I
company?
think we're just determining the schedule of witnesses.
Thank you.
tomorrow.
Okay. I believe that leaves us for, we have the Maryland Energy Group, MEG's witnesses tomorrow. I believe we have 2 scheduled, so we'll reconvene at 10 a.m. tomorrow morning.
Thank you.